Imagine signing up for a streaming service and accidentally selling your soul to a corporate giant. Sounds like a Black Mirror episode, right? Well, buckle up, because reality just got stranger than fiction. Today, we're diving into the case that makes Mickey sweat. A David versus Goliath battle where Disney's attempt to dodge a lawsuit might just be their biggest blunder since Song of the South. And by the end of this video, you'll never look at those I agree buttons the same way again. Welcome back to Uncivil Law. Today, we're discussing a tragic tale that occurred at Disney. It all started with a dream vacation, but it turned into a nightmare faster than you can say bibbidi bobbidi boo. Dr. Kennekaporen Tangsun and her husband, Jeffrey Piccolo, were living their best life at the happiest place on earth. But when they decided to dine at Raglan Road in Disney Springs, things took a turn for the worst. Dr. Tangsun, who has a severe allergy to both dairy and nuts, was assured multiple times that her meal was allergen-free. Spoiler alert, it wasn't. Imagine this: a couple, excited about their magical evening, meticulously explaining their dietary needs to a waiter. The waiter, nodding confidently, assures them everything will be fine. It's a scene that plays out in restaurants every single day, but this time it ended in a tragedy. Within 45 minutes, the doctor suffered a severe allergic reaction. Despite eventually being able to use an EpiPen, you know, that life-saving device that's sometimes portrayed as a magic wand in these situations, she tragically passed away later that evening. It's an unfortunate and stark reminder that in the real world, not every story has a fairy tale ending. Now, a more naive person might think that this would be where Disney steps up, takes responsibility, and tries to make things right. But we know to expect less from the mouse. Brace yourselves, because this is where our story takes a turn into the twilight zone of corporate legal strategies. Enter Disney's legal team, armed with a strategy so audacious it would make Cruella de Vil blush. Instead of taking the tragedy head on, Disney decided to play a game of legal twister that would make even the most seasoned lawyer dizzy. Their grand plan? To force the case into arbitration based on, get this, Mr. Piccolo's Disney Plus free trial subscription and his use of the My Disney Experience app. That's right, folks. Disney essentially argued by clicking that I agree button on the streaming service, Mr. Piccolo had signed away his right to sue them for, well, anything. Disney's argument is like saying that because you once bought Mickey's ears, you've agreed to allow Goofy to perform your next root canal. This isn't just moving the goalposts. It's like Disney picked up the entire football field and relocated it to the moon. They're trying to turn a simple click of the mouse into a magical contract, more binding than Cinderella's shoe and more far-reaching than Rapunzel's hair. But of course, it somehow gets worse. Let's dive deeper into this rabbit hole and see just how far into Wonderland we can go. Disney's lawyers dove into the fine print of the agreement like Scrooge McDuck into his money bin, hoping to find gold in the form of legal loopholes. They pointed to 3 agreements: the Disney Plus subscriber agreement, the Disney Terms of Use, and the My Disney Experience Terms and Conditions. Each of these, Disney claimed, had an arbitration clause that covered all disputes with Disney and its affiliates. It's as if they were trying to create a legal force field around the entire Disney empire, powered by clicks of unsuspecting users. Imagine, if you will, a world where clicking agree to a streaming service is like signing a blank check. You think you're just getting access to The Mandalorian, but surprise! You've also agreed to let Disney handle any future disputes in a secret underground lair, probably guarded by animatronic pirates. But Disney's argument seems to be more of an illusion. Like a magic trick that falls apart under scrutiny, Disney's argument starts to unravel when you look at it closer. First up, the Disney Plus agreement. This agreement, as you might expect, is all about the use of streaming services. Unless Mr. Piccolo was trying to sue because Frozen 2 buffered too much, this clause doesn't seem to apply. Next up, the terms of use. These cover digital products, not real-world tragedies. It's like trying to use the rules of Monopoly to govern actual real estate transactions. And finally, the My Disney Experience terms. These are for park tickets, not restaurants that don't require admission. It's like saying that because you drove to a concert you bought a ticket for, the band now owns your car. But hold your hats, folks, because Disney's got one more trick up its sleeve, and it's a doozy. Just when you thought Disney had overplayed its hand, they throw in a plot twist that would make a scriptwriter proud. Here's the kicker. Mr. Piccolo isn't suing for himself. He's representing his wife's estate. It's like Disney is trying to bind a ghost to a contract someone else signed. The legal term for this is a non-signatory binding, and the legal argument, as you might expect, is typically as solid as a sandcastle in a hurricane. Courts have repeatedly said that you can't bind a deceased person's estate to an arbitration agreement that is signed by a family member. This isn't the Haunted Mansion, Disney. You can't just decide that grim, grinning ghosts come out to socialize in arbitration. This move is so outlandish, it's like Disney's lawyers took inspiration from their own movies. Perhaps they watched Freaky Friday one too many times and thought, hey, if Lindsay Lohan and Jamie Lee Curtis can switch bodies, surely we can make a living person's contract apply to a deceased person's estate. Disney's legal strategy here isn't just shaky. It might be shooting itself in the foot faster than Yosemite Sam at a quick draw contest. In trying to avoid the courtroom, Disney appears to have bought itself a first-class ticket to PR disaster land. The public reaction to Disney's strategy has been about as positive as the reviews for the Star Wars holiday special. In trying to shield itself, Disney has painted a picture of a corporate behemoth attempting to use streaming service agreements for a dodge of real-world responsibilities in a tragedy. It's not just deeply legally dubious, it's a PR nightmare that's spreading faster than a let-it-go earworm. This maneuver has so far turned Disney from the House of the Mouse into the House of Scrooge in the public eye. It's as if they took their own villain playbook and decided to act it out in real life. You can almost hear Scar from The Lion King whispering, "Long live the king," as Disney tries to push this case off a legal cliff. But here's the real kicker. Even if Disney somehow won this argument, they still lose in the court of public opinion. It's like winning that game of Monopoly by burning down all the hotels. Sure, you've technically won, but no one's going to want to play with you again. So what's the moral of this not-so-fairy tale? In the end, Disney's attempt to turn tragedy into a technicality is likely to fail. The court is probably going to see through this legal sleight of hand faster than you can spot the hidden Mickeys in Magic Kingdom. This case isn't just about one family's tragedy. It's a cautionary tale about the limits of corporate power in the digital age. It's a reminder that behind all the magic and wonder, there are real people, real consequences, and real responsibility. Disney tried to use the fine print as a magic wand, but instead may have just turned themselves into the villain of their own story. It's also a wake-up call for the consumer. Those terms and conditions we blindly agree to, sometimes they have more provisions in them than we might think. The average consumer might be signing a magical contract without realizing that we might be trading our voices to Ursula the Sea Witch. But perhaps the biggest lesson here is for Disney itself. In trying to avoid the lawsuit, they've created a much bigger problem. It's like they tried to sweep up some dirt under the rug and ended up burying themselves in an avalanche. Sometimes the best way to handle a problem is to face it head on with honesty and compassion rather than trying to make it disappear with legal magic. As we return from this legal neverland, I want to leave you with 3 questions to ponder. If Disney's arguments were to succeed, what implications would this have for the consumer rights in the digital age? Should companies be allowed to use unrelated service agreements to limit liability in personal injury cases? And how might this case change the way we view and interact with click-wrap agreements in the future? Let me know your thoughts in the comment section below. And remember, the next time you click on I agree on a terms of service, you might want to check if you're accidentally giving away your rights to your firstborn, unless you can remember the name Rumpelstiltskin. Until next time, I've been Uncivil Law, and remember to keep it uncivil out there.